All right, good morning, everyone. Thursday, April 17th, we are continuing work on S59, an act relating to amendments to Vermont's open meeting law. We have a notable lineup of folks who want to share with us today, and I guess we will kick off with Mr. Crowley, who's first on the punch list. Yes, if you'd like.
And Catherine,
Please do. Yeah. All right, yes, duets. We love
Do
them.
we have enough chairs? Hold on now.
Thank you for the time this morning. Good morning. My name is Charlie Baker, Executive Director of the Chittenden County Regional Planning Commission. And
Hi, I'm Catherine Dimitruk. I'm Executive Director of Northwest Regional Planning Commission.
and we're also here providing testimony on behalf of all the RPCs. Catherine, take it away.
Thanks very much for having us here today. As political subdivisions of the state, the Vermont RPCs follow the open meeting law in all of our work. And we also spend considerable time advising our communities and other public bodies on how to adhere to the open meeting law. And so it's with that experience that we offer just a few comments on S59. We actually didn't have anything considerable that we wanted to offer, but just really 2 points that we'd like to suggest. The first is that on page 3, line 9, there's a requirement that local non-advisory public bodies record meetings. And we think it's really important to add an exception here for site inspections and field visits, just because of the logistic difficulties in that. And so we hope that you're able to add that change to S59. And then finally, on executive session, the additional language added here for executive session on page 4, line 4 is really great. I think it's a great clarification for how public bodies should put executive session on the agenda, that it's a proposed executive session because you can't make it a formal one until there's an actual vote to do that. I do think that that would be improved by requiring that the topic of the executive session also be on the agenda, because often you'll see just executive session and reading the agenda, you can't know what that's about. So I think that that would be improved there. And then finally, we just wanted to amplify a few items that we understand are a priority of Vermont League of Cities and Towns and currently aren't in S59, but we'd like to suggest be considered. The first is create exemptions for working groups. It's not clear that working groups can be exempt from the open meeting law, and it really does hamper the ability of our local volunteers to get work done. This is also an issue for other public bodies, such as the new Land Use Review Board. And so we do think that carving out a working group exemption would be really helpful for the work of our communities to move forward in an efficient way. And finally, we think, next to last, we think it would be helpful to really clarify that discussions of cybersecurity are one of the reasons that you can go into executive session. It's not clear that public safety and security completely includes cybersecurity concerns. So we think that would be a good addition. And then finally, because we are required now to record and post meetings, we would like the ability to edit out inappropriate materials before we post that, Zoom bombing issues, other things like that, provided that we would still retain the original recording in its unaltered form. So it would be available to the public, but we don't want to have to post that publicly. So that's it. Very brief. Thank you.
Okay. We're I think after today, we're gonna take like the thoughts and opinions from the testimony we've taken, start trying to like refine some language. So just to give you a heads up, that's kind of like our course of action right now, is to start trying to hone things in and have an amendment to present in the near future. So any questions for our guests here? No? All right.
Thank you very much.
Yeah, hang out and maybe we'll have something else for you, but thank you. Mr. Cohen.
For the record, my name is Matt Coda. I'm with the firm Meadow Hill. I'm here on behalf of the Vermont Communications Union District Association. I was here last week. Thank you for the opportunity to speak. CUDs are unique. They were formed during COVID and they've never had a physical location. Many are run by volunteers, one executive director. And the request, the map is just to familiarize yourself with the different territories of the CUDs. These are the entities that are municipalities that are delivering broadband internet to rural areas of the state. And the request, the language request that I submitted is probably the opposite of what you've been hearing, which is every meeting is recorded, complies with open meeting law, is all digital. Our hangup is the in-person requirement. So what we're asking for is recognizing that there are some municipalities that do comply with open meeting law, but do not have a physical location. And some, the district is so large. You look at NEK, the one in the right-hand corner there, NEK CV, it expands from Roxbury all the way up to Canaan. That's a 2.5-hour drive. It's over 100 miles. So to comply with it, to check the box, you could just pick a town hall or a public library in one of those many districts, over 70 districts. But if it's in Canaan, it's not helping out the person in Roxbury. What we do now, and what we will continue to do, and what the language demands that we do, that we submitted, is that when someone requests that I need a public space, that we accommodate that request. I think that's a much more effective way to ensure that everyone can participate in these processes in an open way, transparent way, not just review the recorded video after the fact, rather than asking a volunteer to open up a space in the town hall that may be 2 hours away from where the person actually wants to participate in the meeting. So we think this is a better way, but it is technically not how it's supposed to be. So we would ask for that exemption based on that language.
Representative Hingham?
So just to be clear, if an individual pick a location, but I can't read this fine print. So if an individual in the Northeast Kingdom requests to have an in-person meeting, you would find a location that's really close to where they need to be meeting from and designate that spot. So you would have to coordinate with somebody in that town to open a public building or a public space for that individual who requests it. Have you had success doing that? And have you had pushback on like, oh no, that would mean a town employee has to go do X, Y, and Z for this?
So there's two pathways. So one is open, when you post the meeting, you simply pick a town hall or pick a public library, a public space that you have to borrow or pay for, and then publicize that is the one location that they have. That effectively follows the law.
Right.
But the better way, the way we'd like to do it, is that if someone says, I live in Roxbury and I don't want to drive to Canaan and I don't have a computer where I can participate in the meeting, that an accommodation is made to help that person get online. So they can participate in the meeting online rather than opening up a second meeting in Roxbury or having them drive. Because they can comply with the law by simply saying, sorry, you got to drive 2.5 hours. But it's a much better way, in a way that the CUDs currently do, which is to help accommodate people that may not have access to an online meeting because they don't have an internet connection.
Right, but that still requires a location somewhere, an in-person location. So have you had problems doing something like that? Or have you not been asked to do?
Not that,
Okay.
but I can tell you that the CUDs so we got a 6-month extension thanks to the work of this committee last year. So it really take effect for us until January 1. And so CUDs that are over the last 3 months in complying with this law have opened up, picked a place, opened up a place for an in-person. They have 0 people have attended on person. So we think that that's more effective to get more people involved, rather than picking a place randomly within the territory, providing the resources and the access to attend online for those that can't do it from their own home.
So that would have to be decided ahead of time. So the individual would have had to request a certain amount of time ahead of time. Is there a specific time frame that you feel would be reasonable to have that request made if it's a non-designated location that you had already decided on.
But when all these meetings are warned, that, I think that gives the opportunity for someone to say, oh, I want to participate in that meeting. And I can't attend online because I don't have access. I understand that I don't want to drive all the way to Gillendale to get there. And that would be the timeframe. When a meeting is warned, it becomes apparent what the agenda is. That's when people frankly want to find out, when's internet coming to my town? I want to participate in this meeting.
I guess my question was, do you think the time frame that's offered between when the agenda is posted and the actual meeting is going to take place, is that enough time to find a location?
Yes.
Okay. Thanks.
Revenue.
I was just wondering, if you could say more about why, you feel that that's like the best way to do it. And I guess the other question would be, if you have to do it, that ends up being like required, what would work?
So required to have an in-person or required to have, provides the accommodations for an online option?
Yeah, like what makes you feel like that's the best way to go about it now? And then if you do end up having to have a physical location, how you would imagine that working best?
So the feedback that we've heard from CUDs is that in order to comply with the open meeting law, as of January 1, they've had to find a physical location, determine where it is, and staff it. So someone's available. And these are volunteers, and they don't have a city hall or town hall because they're CUDs or an open meeting space. So, and understanding that every CUD is slightly different. Some, it's very challenging to provide access, in-person access, the larger it is. So recognizing that they want participation from the community, how can they ensure that? And the best way to do that, they've found, is when someone says, I want to participate in the meeting, being able to provide a location that they can attend. And it's going to be a lot closer than if they, in many cases, than if they had to randomly choose a spot. And it's not consistent. You know, they don't own the facility. Like when we go to City Hall, we know exactly where that is. It could change based on need and availability when you don't own your space.
Is there like a warning period for when you have to say where the meeting is going to be?
Yes, and it would comply with existing open meeting law, which is 14 days, is that correct?
2 weeks.
So if a request to hold, if I'm like, please I need the meeting to be near me in Charlotte, it has to come, that request has to come 2 weeks or more before the date of the meeting.
Right, and the request wouldn't be to have a public meeting in Charlotte. It would be to have someone in Charlotte have access to the central school or the library in order to access the online meeting.
Okay,
So the meeting wouldn't be in person there. It's
right, but it would be
remote access.
and that request would have to be 2 weeks before, or it could even be the date.
That was sort of my question.
Yeah,
Yeah,
that's,
I'm just trying to, I guess what I'm trying to figure out is,
those are good questions, yeah.
what I'm trying to figure out is what the impediment is to having a location required and then also having that access for someone who lives far away. Like they could exist simultaneously.
Right.
In theory, correct? So it's not like you would have to cancel the public location in one place in order to move it somewhere
Right,
to accommodate someone. You just might have to set up.
right. To be clear, from the CUD's perspective,
Yeah.
without having a physical location, without having a consistent staff that can open a physical location, we're relying on a network of volunteers.
Mhm.
Preference is no physical location.
Right.
And understanding that we want to ensure that everyone who can participate in these processes has an opportunity to finding or working out a system in which someone can participate online, even if they have to go to a public space such as a library or a school or a city hall.
Do you remind me, I know in Lamoille, we have a representative for each town, but we're one of the smaller CUDs. It's not the same model for the larger ones as well.
That's right.
Thinking about like if somebody from Northfield asks for a request, are they gonna get regional help or somebody from their town to help them?
That's exactly right. Every town that votes to be part of a CUD has a representative. So the largest one that I frequently reference is NEKCV, which has over 70. So there are 70 different members as part of that decision-making process. In addition, there's members of the public that may want to attend, covering a pretty big swath of Vermont. So yes, so they would either attend online from their home or they currently do attend online from their home, or they go to that one location that they've had to over the last 3 months, but no one has attended an in-person meeting. Or they would go to where they do have access or a good connection where they can participate. Or they can pick up the phone. I mean, it's also, all these things are, they can participate without video as well. You don't have to have a video connection in order to participate in an online meeting. You have to have a phone line, cell or landline.
The old school still works. Anything else for Mr. Cohen?
Thank you for your time. Please join.
Good morning. And thank you for having my testimony today. I'm Lauren Glendavidian with Vermont Access Network. We are the network, as you well know, of community media centers across the state. We certainly appreciate your support of our request for funding that's gone over to the Senate side. Thank you for that. Today, I'd like to testify briefly on S59 as a follow-up to testimony provided by Megan O'Rourke. If you find that under your public testimony, we submitted a couple of weeks ago. I just wanted to put a fine point under it. 2 points. The first is that Vermont Access Network, the 24 community media centers or access management organizations, work with municipalities across the state to provide hybrid meeting coverage. And we want to make sure that S59 accommodates that. And so in section 6A, it says a public body of a municipality or political subdivision, except advisory bodies shall record in audio or video form any meeting, et cetera. And we would like to be sure that just one thing is added, which is shall record or cause to be recorded, so that this contemplates that there is a third party that can make sure this work gets done. In many cases, it's access management organizations, but sometimes it's yet another third party entirely. So it's really just a small linguistic piece. Second point is that while there are many municipalities that are providing hybrid meeting coverage in conjunction with access management organizations, there are many that are not and who have spoken to say this is quite expensive operation. It's in effect an unfunded mandate. And we just wanted to underscore that can be challenging to finance hybrid meeting coverage because the cost of setting up the equipment, the cost of having staff to support the hybrid meeting, because as you well know, it's hard to run a hybrid meeting without staff support because you're in effect running two meetings. You're running an in-person meeting and an online meeting. And then the cost for storage or posting video is not insignificant as it accumulates. And over time, depending on how long you require that video to be stored, that can become an expensive operation. We're all for transparency, and long-term archiving. So VAN prefers to have these posted as long as physically, humanly, financially possible. But we just wanted to draw your attention to the fact. And Megan O'Rourke, who filed the testimony for VAN, I think may be here Uncommon Good Nonprofit Day next week, Tuesday, so she could answer any questions about the cost associated attendant to hybrid coverage if that was of interest to you. Therein ends my testimony.
Any questions for Lauren Lynn?
Thanks again.
Of course. All right. Yep, you got Tucker down. If you'd like to join us, sir.
Good morning, everyone. Tucker Anderson, Legislative Counsel. So happy to be here and talk about one of my favorite subjects in Vermont law, the open meeting law. I am a bit of a Luddite, so it's going to take me a second to figure out how to join your Zoom. Autumn, if you could send me the link.
Take your time, sir.
The plan for this morning is to walk through the underlying law, the open meeting law, to discuss what is required, to do a little bit of a retrospective look at some of the recent acts starting from 2017, some of the temporary authority that was adopted in response to the COVID-19 pandemic, and those pieces that persisted into last year's Act 133 and many of the issues that have been brought up already. After we have grounded ourselves in the open meeting law, we will then move into the requests that have been formally submitted to the committee by witnesses so that you can tee up the policy choices that have been presented to you and understand whether those are necessary given the state of the open meeting law right now, and the guidance that we may or may not have from the courts on how to interpret the underlying statute. Just take a look here to see what Autumn has sent me. And I'm sorry that I didn't do this before. I was furiously taking notes on some of the more recent requests. Furious is in anger, furious is in fast. So the open meeting law really does get me fired up.
Hey, this Zoom's working today.
Oh. That's very exciting.
Do not inure any benefits. So obsessed with the open meeting law. Thank you, Autumn. Lots of wonderful notifications here. All right. To start, you might be thinking, what is this? What could I possibly be looking at on the screen right now? Representative Waters Evans asked that I start today by discussing the earlier proto-democratic processes adopted by the Icelandic parliaments, specifically the Icelandic Althing, which is the first parliament ever. And in around 934 AD, they started meeting in what was known as the Ula Elting. And these were meetings that were held once a year. And that term in Old Norse means a general assembly, the Elting. They would meet in an open field in a circle. This is a diorama from a museum that displays some of the Viking era tings that were held in Iceland. In the center would stand someone known as the Lostiment, which is the law speaker, or as we call it today, the speaker. All of the representatives from the various farming areas, they were districts, so they had apportionment that was fixed by contract, would sit in the middle circle, and in front of them and behind them would sit their constituents, nobles. And then all around them in the fields would stand the public, and the General Assembly acted as both the legislature and the judicial system for the people of Iceland. And this practice persisted into English common law, into the earlier colonial frames of government, including Vermont's initial meetings chartered by Benning Wentworth, the governor of New Hampshire when Vermont did not exist yet, and there was the colony of New Hampshire, and into modern day Vermont. So it was the practice for over 1,000 years until 2020. It was the practice of all public bodies to meet in an open area where the public physically attended and observed the meeting. So
Thank you.
let's talk about the open meeting law and what has changed in very recent history. Hopefully you can all see the entirety of the wonderful 1 VSA section 310, which is the first section of the open meeting law and contains vital definitions for understanding the subchapter, its procedures, and especially its application. I'm not going to go in order of the definitions because I'd like to talk about some of the changes from Act 133 as we get later on into our understanding of the open meeting law. I will start with definition 6, public bodies. I'm not going to read it exhaustively. You can think of this as essentially any decision-making body, including commissions, councils, working groups, and their subcommittees at both the state and local level, all political subdivisions of the state. Okay, that's what we're talking about whenever we use the term public body. And later on, I will note one very important technical correction that needs to happen in the heading of a section of the open meeting law that seems to be a persistent error through the ages, which is that section headings uses the term public agency. So, public bodies. Anytime a public body meets, the open meeting law is triggered. We know what a public body is. Now we need to understand what a meeting is. Subdivision 5 establishes both what a meeting is and what a meeting is not. So, a meeting means a gathering of a quorum of the members of a public body. A quorum, unless separately defined, means a simple majority of the members of the public body. For the purpose of discussing the business of the public body, there's a separate definition that was added in 2017 for the purpose of taking action. Are there any questions on that first general definition of what a meeting is? Okay.
So just to clarify, when a public body meets for, say, a training, that does not trigger, even though there is a quorum.
Correct. And we will get to that in a moment because it is one of the express exclusions from the definition of what a meeting is. Okay. A meeting shall not mean any communication, including email, telephone. There's a non-exhaustive list there between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting. Okay, so you have, this was also added in 2017. And this distribution of materials, there's no discussion happening yet. Some of the administrative things that you all do and other public bodies of the state definitely do. Provided that no other business of the public body is discussed or conducted in those communications, and that the communications result in written or recorded information that shall be available for inspection and copying under the Public Records Act. These two Romanette subdivisions address an issue in open meetings broadly, very covered extensively in a very excellent treatise by Schwing called Open Meeting Laws, called Serial Communications. So in other states, surely not in Vermont, one of the ways that public bodies were circumventing the purpose and intent of their open meeting laws was to effectively discuss all of the business of the public body through email chains, and because they were not gathering, it was not subject to the open meeting law. So the General Assembly addressed this with these two Romanettes saying, you can communicate concerning some of these administrative matters serially, provided you're not discussing the business of the public body, and provided that anything that is written or recorded is available under the Public Records Act. Subdivision C contains another exclusion. Meetings do not include occasions when a quorum of the public body attends social gatherings, conventions, conferences, training programs, press conferences, media events, or otherwise gathers, provided that the public body does not discuss specific business of the public body that, at the time of the exchange, the members expect to be business of the public body at a later time. So incidental gatherings, social gatherings of a public body are totally fine, provided that a quorum or more is not getting together and effectively making decisions and discussing the business of the public body that is later going to be an issue in a meeting of the public body. Okay. So let's talk about what the business of the public body is. It's the public body's governmental functions, including, and remember, including in Vermont statute means including but not limited to. This is non-exhaustive, but great examples. And the open meeting law loves the words that were added here for the business of the public body. And you're going to recognize one of those words immediately as having distinct importance in Act 133. So, including any matter over which the public body has supervision, control, jurisdiction, or advisory power. This list is going to show up in the distinctions between advisory bodies and all of the other public bodies of the state. Are we feeling okay? Great. We're going to skip again around. Sorry for jumping around so much, but we use alphabetical order for some reason, not Tucker's instinctive order of how to the open meeting law. Subdivision 8, we have a definition, a specific definition for purposes of the open meeting law for what a quasi-judicial proceeding is. And I can send the committee a case that evaluates both what is quasi-judicial in broad terms and what a quasi-judicial proceeding is for purposes of the open meeting law. But here it's a contested case under the APA or a case in which the legal rights of one or more persons who are granted party status are adjudicated, conducted in a way that all parties have an opportunity to present evidence, cross-examine witnesses, and results in a written decision. Okay, effectively a judicial process. That becomes important because there are exemptions from the open meeting law later on for the deliberations in relation to a quasi-judicial proceeding. Deliberations is defined. It means the weighing, examining, and discussing the reasons for and against an act or decision, but expressly excludes the taking of evidence and the arguments of the parties. So when we get to that exemption from the open meeting law later on, which must be strictly construed according to the Supreme Court of Vermont, we are talking about when those quasi-judicial bodies are weighing, examining, and discussing the reasons for or against an act as part of one of those contested cases, meeting the definition of a quasi-judicial proceeding. Now we can get into some of the fun things that were introduced by Act 133 section. Before we get into what an advisory body is, I would like to state expressly, public body. That is a term that covers all of the things that we are talking about. Anywhere where public body appears in the open meeting law, it applies to all public bodies, unless there is an express exception granted somewhere, right? advisory bodies are still public bodies unless they are given some sort of express authority to deviate from the procedures that are applicable to public bodies. Why do I know that confidently? Because the definition of advisory body states that it means a public body that does not have supervision, control, or jurisdiction. The first three terms used to describe in that including clause examples of the business of a public body over legislative, quasi-judicial, tax, or budgetary matters. That list at the end, developed as policy choices in Act 133 as it was being extensively discussed in Senate government operations. To my knowledge, the House did not alter this definition after it came over from the Senate. But those were the four areas that the Senate identified as being important enough to say, no, you are still going to be in the broader definition of public bodies. You're not going to get the advisory body exceptions if you have supervision, control, or jurisdiction over legislative, quasi-judicial, tax, or budgetary matters. There's been some pointed confusion recently over what matters means. And the only response that I have about what a matter is that it is another term that has been used in the open meeting law since the 2017 amendments to describe what the business of a public body is. So maybe shorten this in our understanding. If you have supervision, control, or jurisdiction over a budget, you likely are captured. Hybrid meeting, we can dispense of fairly quickly. I think you understand what it is just based on the fact that all of your meetings are hybrid meetings. It's a meeting that includes a designated physical meeting location and a designated electronic meeting platform. Okay. Unless there are questions, we can jump into the procedures. I skip section 311 of the open meeting law because it contains statement of purpose in the shortened title for the open meeting law, essentially allowing us to refer to it as the open meeting law without having to expressly cite the subchapter in other areas of law. All right. In section 312, all meetings of a public body are declared to be open to the public at all times, unless it is an executive session. No resolution, rule, regulation, appointment, or formal action shall be considered binding except as taken or made at such open meeting, except as further provided under a subdivision that covers electronic meetings. A meeting of a public body is subject to the public accommodation requirements of Title IX. And I want to emphasize that because some of the testimony that the committee heard about new requirements for hybrid meetings conveniently skipped over existing requirements for Title IX requirements. And I'm talking specifically about field visits. If you're going to hold a meeting of a public body at a field visit, the requirement in existing law is that it be held somewhere that meets Title IX requirements. There's going to be an exception built into underlying law, was not affected by 133 for certain types of field visits and site inspections that we'll get to a little bit later in the section. All right. A public body shall electronically record all public hearings that are related essentially to hearings about rules under the Administrative Procedures Act. So we're talking about state agencies holding their public hearings about rules have to be recorded. That's something that existed in the open meeting law before Act 133. The public shall have access to hard copies of the electronic recordings. Subdivision 2 of subsection A, another part of the open meeting law that existed before Act 133. And there has been some confusion about this subdivision in particular. Testimony here and in the Senate from some municipalities talking about the requirements for roll call if they were to hold an electronic meeting. And I'm going to point to a few things in here where that requirement is only triggered when the members of the public body are attending through electronic means, which is what this subdivision covers. So, as long as the requirements of the open meeting law are met, one or more of the members of the public body may attend a regular, special, or emergency meeting by electronic or other means without being physically present at a designated meeting location. If one or more members attend in this manner, the members may fully participate in discussing the business of the public body and voting to take an action, but any vote of the public body that is not unanimous shall be taken by roll call. So there's the roll call requirement. It is triggered when members of the public body themselves are not physically present at the designated meeting location and are attending electronically, and it is only triggered when there is not a unanimous vote on an issue. Each member who attends a meeting without being physically present at the designated meeting location shall identify himself or herself when the meeting is convened and be able to hear the conduct of the meeting and be heard throughout the meeting. We also heard some other testimony about the expense associated with electronic broadcasting of some of these open meetings, and it was about having microphones for each individual member. That is not required by the hybrid meeting requirement. The requirement for the members to be heard is triggered again by a member not being physically present and attending electronically. And that's for those who are not at the designated physical meeting location. Okay, subdivision D. This is going to get into some of the agenda requirements specifically for this participation through electronic means. A quorum or more attends a meeting without being physically present. The agenda that is required under sub D of this section shall designate at least one physical location where a member of the public can attend and participate in. So this was the issue that came up during COVID, and it was addressed by some of the temporary authority. Members of the public bodies were going to be meeting electronically under this existing law. But they needed to have a designated physical meeting location where either members of the public body or a member of staff of the public body had to be present. And that is what was suspended in some of the temporary authority that I'll walk you through in just a moment. Newly added to this, because there's some authority for advisory bodies to meet completely electronically without designated physical meeting locations, is the sentence at the end. The requirements of this subdivision shall not apply to advisory bodies. Okay. Now we're going to get into some of the Act 133 stuff. Any public body of the state, except advisory bodies, shall hold all regular and special meetings in a hybrid fashion, which shall include both a designated physical meeting location and designated electronic meeting platform. They shall electronically record all meetings, and for a minimum of 30 days following the approval and posting of minutes, retain the recording and post it in a designated electronic location. A few things to point out immediately for some of the concerns that you've heard. The very first word in the heading, added by the House Government Operations Committee last session, is state. The first operative clause in this subdivision, any public body of the state conforms with the definition of public body, which separates the state and the public political subdivisions of the state for purposes of exhaustively listing all of the various public bodies that are subject to the open meeting law. The hybrid meeting requirement applies to state public bodies. I will flag for you as we go throughout where the General Assembly chose to call out requirements for local public bodies. Now we get into advisory bodies broadly in subdivision 4 and the ability to meet electronically without a physical meeting location. So a quorum or more of the members of an advisory body are allowed to attend any meeting by electronic or other means without being physically present at a designated meeting location. They may attend an emergency meeting of the body by electronic or other means without being physically present at or staffing a designated meeting location. That's for any public body. For state non-advisory public bodies, state and local advisory bodies. This covers designated electronic platforms that are used for some of those electronic meetings in the preceding subdivisions. So if you're meeting under subdivisions 3 or 4, the public body is required to designate and use an electronic platform that allows the direct access, attendance, and participation of the public, including access by telephone. And this sentence is taken directly from the COVID response temporary authority. Public body is required to post information that enables the public to directly access the designated electronic platform and include this information in the published agenda or public notice for the meeting. That was from some of the later temporary. Okay. Subdivision 6, this applies to your local non-advisory public bodies. The public body of a municipality, except advisory bodies, shall record any meeting of the public body and post a copy of the recording in a designated electronic location for a minimum of 30 days following the posting of minutes. Skipped over the approval and the official because it's taken out in S59. Municipalities are exempt if they can demonstrate that doing so would impose an undue hardship, and the burden of demonstrating that there's an undue hardship is on the municipality.
Is an undue hardship could that be financial?
Yes.
Okay.
Correct. It is expressly defined in 1 VSA 310 as an action required to achieve compliance that would require significant difficulty or expense in light of factors including, but not limited to, the overall size of the entity, sufficient personnel and staffing availability, the entity's budget, and the costs associated with compliance. S59 proposes some amendments within this subdivision to state first that the threshold is necessary instead of sufficient personnel and staffing availability, and that we're talking about, instead of the entity's budget, it's not the public body, we're talking about the entity above. Right. So if you're talking about municipal public body, you're talking about the municipality's resources. This was the example used last session very frequently, the garden club's resources and budget. Subsection B, which you've actually already taken a little bit of a dive into, so I won't get too deep on this, requires meeting minutes to be taken. Needs to cover all topics and motions that arise, give a true indication of the business of the meeting. At minimum, it must detail the members of the public body present, all other active participants in the meeting. So we're talking about testimony from the public potentially, or witnesses that are called before the public body, all motions, proposals, and resolutions made, and what the disposition was on those proposals and motions, and the results of any votes. Individual votes have to be recorded in case of a roll call. Minutes are public records, shall be kept by the clerk, and shall be available for inspection by any person. Minutes shall be posted no later than 5 calendar days from the date of the meeting to a website if one exists. Except for draft minutes that have been substituted with updated minutes. Posted minutes shall not be removed from the website. And that is the sentence that led to some of the language that is now struck by S59 concerning the approved official minutes, right? Subsection C. You got ahead of me in some of the discussion about when a designated physical meeting location must be noticed. And I believe that the timeline that was thrown out was 2 weeks. Regular meetings, a little different here. Because the time and place of all regular meetings shall be clearly designated by statute, charter, regulation, ordinance, bylaw, resolution, or other determining authority of the public body. When we're talking about some of these instruments of setting the time and place, it is likely they would have to be adopted in open meeting, right? So if you're going to change the meeting place for an upcoming meeting, you're likely going to have to adopt some sort of governing structure for changing the place of your regular meetings. We'll get into special meetings in a moment, which only require 24 hours notice. The time, place, and purpose of a special meeting shall be publicly announced 24 hours before the meeting. And publicly announced does have a definition that I can point you to. Municipal public body shall post notices of special meetings in or near the clerk's office and at least 2 other designated public places in the municipality at least 24 hours before the meeting. And I'm only going through that one exhaustively because I believe you have a request to address that in S59. Notice has to be given to the members of a public body. And just in case you're thinking about this, once we get to the penalty section, members of a public body can bring a complaint about open meeting law violations. They have an interest that can be harmed. So they have standing according to the Supreme Court. Emergency meetings may be held without public announcement, without posting notices, and without 24-hour notice to members, provided that some public notice is given as soon as possible before any such meetings. Then you get to a limitation in the next sentence that they may be held only when necessary to respond to an unforeseen circumstance or condition. Right. Any adjourned meeting shall be considered a new meeting unless the time and place for the adjourned meeting is announced before the meeting adjourns. So that's just making sure that if a public body is going to hold an adjourned meeting, that there is sufficient notice under the preceding subdivisions. Subsection D, agenda posting, 48 hours before a regular meeting, 24 hours prior to a special meeting, has to be posted to a website if one exists. In the case of municipal public bodies, the agenda has to be posted in or near the municipal office and at least 2 other designated places in the municipality. Agendas have to be made available to a person prior to the meeting upon specific request. So, for example, some of the practices we have in the General Assembly, if someone wants meeting agenda notices, they can email, well, in the past, they would email legislative operations, and there was a list of, for example, upcoming public hearings that will go out in public announcements saying this is when this particular panel will be meeting. Any addition to or deletion from an agenda must be made as the first act of business, and any other adjustment to the agenda may be made at any time during the meeting. So I brought that up during the walkthrough of S59 that some of the new provisions relating to required components of posted agendas might not have a lot of teeth to them because agendas can be essentially updated at any time during the meeting. Subsection E, immediately start jumping into some of the exemptions here. Nothing in this section or the executive sessions section of this subchapter shall be construed as extending to the judicial branch or the Public Utility Commission. So the PUC and the judicial branch are accepted from the open meeting law. It doesn't extend to the deliberations of any public body in connection with a quasi judicial proceeding, which we already discussed both of those definitions. And it shall not be construed to require the making public of any proceeding, records, or acts which are specifically made confidential by the laws of the United States or of this state. And there is a Supreme Court of Vermont holding related to how we interpret the Public Records Act and the open meeting law. We are not to interpret them in pari materia. So the discussion of an otherwise confidential record in an open meeting doesn't render that confidential record public. Doesn't destroy the confidentiality of the record. Let's skip subsection F and not get too deep. It relates to quasi-judicial proceedings. Making things public. Subsection G is quite relevant to some of the proposals that you are going to consider. The provisions of the open meeting law shall not apply to site inspections for the purpose of assessing damage or making tax assessments or abatements, clerical work, or work assignments of staff or other personnel. So there is an existing site inspection exemption for purposes of assessing damage or making tax assessments or abatements. I recall from watching the testimony from some of your witnesses that those sorts of site inspections were called out as examples for requests for broadening some of the field visit and site inspection exemptions that are granted under S59. So I'll just note that they're not subject to the open meeting law at all.
Okay.
At an open meeting, the public shall be given a reasonable opportunity to express its opinion on matters considered by the public body as long as order is maintained. Public comment shall be subject to reasonable rules established by the chairperson. And of course, this doesn't apply to quasi-judicial proceedings. You have a bill on your wall that deals with subsection H and some of the issues that can come up here. One thing that I would note is an odd quirk about subsection H just generally is that it allows one member of the public body to adopt rules. That's existing authority in the open meeting law, but it's maybe the only example that I can think of where one individual has rulemaking authority.
And that's the
By
chairperson.
the chairperson. Is that a hand?
Yes.
Rep water.
Can you talk about the word reasonable?
Undefined in this context.
Okay.
You can be certain that with some of the First Amendment considerations that come into play with lawful assemblies, that reasonable would be constrained by those constitutional protections, both speech and assembly. And if you do end up diving into some of the background law behind the bill you have concerning this subsection, be happy to give you all of that extensive background. Subsection I deals with the parole board. Subsection J, this is new from Act 133, request for access. So a resident of the area over which the public body has jurisdiction, a member of the public body, or a member of the press is granted the ability to request that a public body either designate a physical meeting location or provide electronic or telephonic access to a regular meeting. So this won't apply to special meetings or emergency meetings, just to the regular meetings, but not to a series of regular meetings, special meetings, emergency meetings, or field visits. That clause, not to a series of regular meetings, was added by the House for Act 133, and it was to clarify that a requester could not compel effectively ongoing hybrid meetings, for example, by submitting a series of requests concerning the regular meetings of the public body.
So just to clarify that, the person would need to, the individual would need to request for access for each and every of those recurring meetings, if it were a series of meetings.
Not only would the individual have to request individually, but that clause on its face is a prohibition against requesting a series, having this apply at all to a series of regular meetings.
So they could be denied, say, you know, the second and third request for a regular meeting access.
Potentially. There's divining some of the legislative intent behind this is going to be difficult. So I don't want to stray into that, but this language is different from terms such as consecutive or non-consecutive that could have been used to better articulate potentially some of the intent behind this. Requests are required to be made in writing not less than 2 business days before the date of the meeting. And the requester does not have to provide a basis. And some of this language, as it came out of the Senate, these were things that were discussed by the Senate Government Operations Committee, an attempt to avoid construing this as a request for accommodations. But that shifted as the bill moved forward, and you got definitions for undue hardship, the undue hardship response, things like that. The body is required to grant a request unless there's an all hazards event or a state of emergency. If there's a local incident that's defined in section 312A, or if compliance would impose an undue hardship. Public body shall have the burden of proving that compliance would impose an undue hardship. Subsection K relates to training, required training for the following officers. For your political subdivisions, the chair of the legislative body, the town manager, and the mayor, and for the state, the chair of any public body that is not an advisory body. The Secretary of State is required to develop these trainings. How do we feel about the open meeting law procedures? Adequately confused? Good?
Revenue?
I still have a really hard time wrapping my head around advisory and non-advisory. I hate both of those terms, and I know that was a choice that we made, but just really still need clarity after all this time. And I understand in theory what it is, but when the words are on the page and it says advisory and non-advisory, I have to go through this whole long process in my head of what does that really mean? And I would love to have different terminology for that. So just a comment.
Yeah, just a comment, then
Yeah.
Rep. Boyden.
I mean, maybe Tucker was about to say this, but I believe S59 looks to clarify that.
S59 looks to strike the use of non-advisory, both because it's not a defined term in the open meeting law, but also because it's an inaccurate description of what those public bodies are. They may be advisory, but they also have one of those other powers: supervision, control, jurisdiction over any one of those 4 things: budget, quasi-judicial matters, legislative power. Right? So S59 strikes non-advisory wherever it's used throughout this. It is your choice as to what these bodies are called. Advisory bodies was chosen because of existing language in the open meeting law describing examples of what the business of a public body is, specifically what their governmental functions might be. And it dovetailed very well with other conversations that were happening in the General Assembly about advisory bodies and panels at the state level. So it was a hot term last biennium and it made its way into the open meeting law because it fit well. But it is not, this isn't the Constitution. So if you have a different term you'd like to use, a different definition that the committee wants to work on, you could, just like erasing those municipalities from the map with Judge John Forrest Dillon's pen, you can change the terms used in the open meeting law.
I feel like non-advisory is the one I have the biggest problem
Yes.
with. Advisory is okay.
Going in the right direction.
Yeah.
And maybe we can make a list of all the things that we wanted to meet. But terms. That'll be fun.
Mm-hmm.
You haven't played with words like that in a while.
Yeah, I like
Still,
Rough stuff.
do you have a question?
Hand up.
Oh, haven't moved.
Okay, and that was a misfire. Best part.
Sorry,
Yep.
saw him.
I don't want to dive too deeply into 312A unless the committee has the appetite for a middle course here. But
So I'm gonna look at the room. How does the room want to play this? We still have ample clock before our next thing. Would we like to take a break and then come back? It's been a little tense. Yeah, we'll make it 10. Yeah. We'll call a 10-minute timeout. Then we'll come back and then we'll dive back into this stuff. And I'm on the only thing. Sure. Sounds good. Yeah. All right, we're gonna take a break for 10 minutes on little bio break.